Speaker, I rise to speak in support of the Summary Offences Amendment Police Memorials Bill 2025, a bill introduced in this House by the member for Barwon and a bill that the government supports. I thank the member for bringing this very important bill to the House. And at its heart, this bill is fundamentally about respect. It is about ensuring that police memorials, places that honour the service and sacrifice of police officers who have lost their lives in the line of duty, are afforded the same clear and explicit legal protection as war memorials and interment sites. These are solemn places. They are places of remembrance, reflection and gratitude. They're places that carry deep meaning not only for the families and colleagues of fallen officers, but for the broader community they served. The purpose of this bill is straightforward but important. It amends the Summary Offences Act 1988 to do two key things. First, it puts beyond doubt that the offence of wilfully damaging or defacing a protected place in Section 8.2 captures police memorials by amending the definition of protected place in Section 8.1 to expressly include police memorials. Second, it expands the offence of committing any nuisance or any offensive or indecent act in, on or in connection with any war memorial or internment site in Section 8.3, so it also captures police memorials. Although it is likely that police memorials are already captured by Section 8.2, because monuments fall within the definition of protected place, putting this beyond doubt will enhance understanding of the offence and its availability in relation to police memorials. By expressly naming police memorials in the legislation, the Parliament is sending a clear message. Conduct that disrespects or damages these memorials is unacceptable. It will be treated seriously under the law. This amendment also plays an important symbolic role by signalling the seriousness of this conduct and showing respect to the police officers who lost their lives as part of their service. That clarity matters. It matters for law enforcement, it matters for the courts, and it matters for the community's understanding of what behaviour is and is not acceptable. The existing offence of wilfully damaging or defacing a protected place carries a maximum penalty of 40 penalty units. The offence of committing any nuisance or any offensive or indecent act carries a maximum penalty of 20 penalty units. As an alternative to a fine for these offences, the court may impose a community correction order with the standard conditions and community service work condition, or the equivalent order for children under Section 8.3a. If a person is convicted of an offence under Section 8 in relation to a war memorial, a compensation order is also available to the sentencing court under Section 8.3b. What this bill does is ensure that those enforcement and sentencing options are unquestionably available when police memorials are targeted. And regrettably, Speaker, this is not just a hypothetical concern. There have been real and distressing incidents. In January 2025, a man was charged after markings were allegedly scratched into a New South Wales Police Wall of Remembrance in Sydney. Abusive words were etched above the names of fallen officers and the New South Wales Police emblem. In 2016, that same memorial was vandalised with scratches and abusive messages. These acts are deeply hurtful and disrespectful. They cause pain to the families of officers who gave their lives in service to the people of New South Wales. They distress serving and former officers, and they offend a community that rightly expects places of remembrance to be treated with dignity and respect.